Environmental, social and governance, or ESG matters, and diverging opinions on approach continue to dominate headlines across the globe in 2024. Companies and their stakeholders started the year navigating between proponents and detractors of ESG. Nevertheless, the topic remains an important one for companies in both the European Union and the US. In this video, we'll highlight key ESG trends and developments in 2024 so far, including the continued pressures of ESG litigation and activist pressure, and ESG backlash in the US and EU, progress on ESG matters despite the backlash. We'll also look forward to what we can expect to see in future, in particular incoming EU regulation and UK greenwashing rules, and how companies and their stakeholders can balance competing demands. Continuing a trend from 2023, ESG activism remains on the rise. Activists continue to promote ESG objectives through litigation and corporate governance structures, and corporates are taking preemptive measures. In Switzerland, the European Court of Human Rights, or ECHR, ruled in April 2024 that Switzerland's efforts to meet its emission reduction targets have been deficient to the point of violating Article 8 of the European Convention on Human Rights, which is the right to respect private and family life. This was the first time the ECHR has given a ruling on the climate change case, but it's unlikely to be the last. In the UK government has also faced the successful challenge by climate activists. In May 2024, the High Court of England and Wales found that the UK's carbon budget delivery plan was flawed. The Secretary of State for Energy Security and Net Zero was determined to have made an irrational decision based on inadequate evidence, because the plan would likely not be able to deliver on its carbon budget. There have also been challenges to initial public offerings. For example, Climate Earth challenged the UK Financial Conduct Authority's approval of Ithaca Energy's prospectus on the premise that it suffered from omissions regarding climate-related financial risks. However, the challenge was dismissed. The High Court found that l'ICA had not acted irrationally in approving the prospectus, which addressed financial risks arising from climate change and contained the necessary information material to an investor. A group of investors of Shell, backed a resolution proposed at its AGM in May 2024, calling for the company to align its medium-term emissions reduction targets with the Paris Agreement. The resolution failed, as was the case for a similar resolution at its AGM in 2023, but the effort highlights the persistence of activist investors in seeking to garner support for resolutions that challenge companies on their climate change goals. But not all activism is seeking to escalate the decarbonisation efforts of companies. For instance, Bluebell Capital has urged BP to drop green commitments and increase the production of fossil fuels. The essence of Bluebell Capital's position is that BP is not well placed to pursue a clean energy growth in a profitable manner, and should instead prioritise distributing funds to investors who can then invest that cash in companies with better prospects of advancing renewable energy profitably. Although it is increasingly common for shareholders to seek to challenge companies on their environmental policies, there are also examples of companies opposing shareholder proposals that may be considered inconsistent with investors' interests, and on the basis that such proposals diminish and detract from the company's existing business, especially where they have been repeated and rejected previously. Since 2023, the ESG movement has experienced turbulence on both sides of the Atlantic. It appears that the ESG momentum has been slowed somewhat by increasing backlash against green policies and climate disclosures in both the US and Europe. Geopolitical events, including Russia's invasion of Ukraine, has increased the demand for oil, which may run counter to activist demands to phase out fossil fuel development. The oil and gas industry has reportedly voiced concerns that consumers may be unwilling to pay the costs associated with a rapid shift from oil and gas to renewable energy. The industry has also pointed to the need for dependable electricity to feed the soaring power demand sparked by the proliferation of data centers needed for artificial intelligence. Additionally, scores of major industrial company executives have raised concerns over what they consider to be the deindustrialization of the European economy. As the energy transition accelerates, they have been urging the EU to cut energy costs and the regulatory burden of green rules to help the region stay competitive. For example, one major oil and gas company had billions of dollars set aside for near-term decarbonization projects, but said that it was likely to prioritize other parts of the world amid the increasing regulatory burden linked to getting projects up and running in Europe. Despite this backlash, it has not prevented shareholder support for ESG-related proposals. Data from market reports suggest that in the US, support for governance and compensation-related proposals at Russell 3000 companies was at unseen levels for the first 5 months of 2024. In 2024 so far, common matters that have received majority shareholder support include those aiming to enhance shareholder rights, reduce greenhouse gas emissions, reduce the supermajority voting requirements for amending governance documents. The volume of environmental-related proposals has decreased, but the support for their passage is increasing once again, following a decline from the 2021 peak. Anti-ESG proposals continue to increase in number, but the support remains low. What remains appears to be a mixed picture, but there may be greater clarity to shareholder sentiment. The rising current of anti-ESG proposals may be attributable to broader litigious activity, and the decline in volume of pro-ESG proposals may reflect the fact that public companies are able to demonstrate green credentials in other ways, such as through compliance with climate disclosure requirements and investment labeling. A combination of new guidance and market practices providing greater clarity over the approach that competition authorities are likely to take in relation to sustainability agreements, i.e. the agreements between competing companies that pursue sustainability objectives. Increasing numbers of jurisdictions in Europe and Asia have adopted guidance for business on how to navigate competition laws when collaborating on green projects. Final or draft guidance has recently been published in the EU, the UK, France, Portugal and New Zealand, as well as Australia and Singapore and Japan. The guidance is being complemented by competition authorities proactively publishing their informal assessments of proposed sustainability initiatives under these so-called open door policies. For example, the UK authority has published assessments in relation to 2 agreements since its guidance was published in October 2023, and the French authority has already published an assessment since its own guidance was finalised in May 2024. Some competition authorities have also incorporated sustainability considerations into their merger control assessments. The European Commission recently set out in a policy document the various ways in which sustainability issues are taken into account in its merger reviews, including aspects such as market definition and efficiencies. While there are currently limited cases in this area in Europe, the Australian authority cleared a transaction in 2023 on the basis that its public benefits, a reduction in greenhouse gas emissions, outweighed the anti-competitive effects. So what do we expect to see in 2024 and beyond? Well, ESG will begin to feature in antitrust policy. As competition authorities publish more guidance based on practical experience, the guidance should provide increasing certainty on the do's and don'ts of sustainability collaboration. Yet the assessments published so far tend to concern lower risk forms of collaboration and consequently shed little light on how to apply more complex aspects of sustainability guidance, such as weighting environmental benefits against anti-competitive harm. This, coupled with the fragmentation and limited adoption of guidance globally, means that legal uncertainty is likely to remain throughout 2024 and into 2025. We may also see sustainability considerations start to feature more heavily in other areas of competition policy, such as merger control. On July the 25th, 2024, the Corporate Sustainability Due Diligence Directive, or CSDDD, entered into force. It's the latest in a series of EU legislative endeavours aimed to protect human rights and the environment through reporting and due diligence obligations. EU member states now have until mid-2026 to transpose this directive into their national laws. The application of the directive itself will be phased in through a staggered approach over a 3-year period starting in 2027. Companies that will be affected by 2029 include a company with more than 1,000 employees on average and a net worldwide turnover exceeding 450 million euros in the last financial year, the ultimate parent company of a corporate group that collectively satisfies that threshold, a company that is entered into or is the ultimate parent company of a group that has entered into franchising or licensing agreements in the EU in return for royalties that amount to more than 22.5 million euros, and provided it had or has the ultimate parent company of a group with a net worldwide turnover of more than 80 million euros in the last financial year. In 2029, CSDDD will apply to further non-EU companies. The directive imposes a number of obligations. Firstly, to set out risk-based due diligence obligations for companies regarding actual and potential adverse impacts to both human rights and the environment with respect to the owner operations, their operations of their subsidiaries, the operations carried out by business partners, and drawing on the widely accepted UN guiding principles for business and human rights, the due diligence process in CSDDD builds on the 6 steps defined by the Due Diligence Guide for Responsible Business Conduct found in the OECD guidelines for multinational enterprises. In September 2023, the FCA and Prudential Regulation Authority in the UK began a consultation on proposals to introduce a new regulatory framework on diversity and inclusion in the financial sector. The consultation closed in December 2023, and policy statements confirming the regulatory framework are expected to be released before the end of 2024. One proposal calls for firms to determine and set appropriate diversity targets in order to focus their attention on D&I and encourage progress. Firms would be expected to set at least one target for each of the board of directors, senior leadership, and the employee population as a whole. Targets and progress towards such targets would then need to be disclosed publicly. Firms may require support and guidance when introducing formal targets in order to navigate the balance between positive action in the form of setting targets and positive discrimination, which is prohibited under the Equality Act 2010. Another proposal that has drawn attention is the integration of non-financial misconduct considerations into fitness and proprietary assessments. The conduct rules, which set minimum standards of individual behaviour, and threshold conditions, which represent minimum conditions that firms must meet to carry out regulated activities. In November 2023, the FCA published Policy Statement PS 2316, setting out the final rules for sustainability disclosure and investment labels. These provide a comprehensive suite of measures which apply in varying degrees to FCA-authorised firms and include an anti-greenwashing rule, which is applicable to all FCA-authorised firms, requiring firms to ensure that communications about sustainability of a product or a service are fair, clear and not misleading. A labelling regime, which applies to UK fund managers and introduces 4 labels that firms can choose from, provided they meet the qualifying criteria. Some naming and marketing rules, product level and entry level disclosures and rules for distributors. So the Corporate Sustainability Due Diligence Directive, or CSDDD, was adopted on the 24th of May 2024 and published on the 5th of July 2024. This gives EU member states 2 years to transpose that directive into national laws. FCA's anti-greenwashing rule came into effect on the 31st of May and applies to all FCA authorised firms. The Transition Plan Task Force, which was launched by HM Treasury in 2022 to develop regulatory gold standards for climate transition plans for companies and financial institutions, public sector-specific guidance in April 2024. This is designed to complement the TPT disclosure framework that was released in October 2023 and includes a sector summary and deep dive providing specific guidance for 7 different industrial sectors. UK's CBAM will be implemented on the 1st of January 2027 and will apply to imports of carbon-intensive goods such as aluminium, cement, iron and steel. And on the 24th of April 2024, the EU adopted the regulation on the transparency and integrity of ESG rating activities to regulate ESG providers that operate in the EU, and that is expected to apply starting 2026. In the US, the SEC has faced a wave of litigation, including from businesses in Republican-led states following its March 2024 rule requiring larger publicly traded companies to disclose material Scope 1 and Scope 2 emissions. These lawsuits, which argue that the regulation exceeds the SEC's authority granted by Congress, have been consolidated in the US Court of Appeals for the 8th Circuit. The SEC has voluntarily stayed its implementation of the rule in light of this pending litigation. The Environmental Protection Agency is urging DC Circuit to keep its rules in establishing greenhouse gas emission standards for power plants and expanded methane emission control requirements amid legal challenges seeking an administrative stay of the rules, including by Republican-led states and conservative groups.